Iowa, obviously my home state, and
So-
Des Moines. It's really good to see you here. We don't have a lot of Iowans come in and testify, so I really appreciate seeing you here today. I think it's very good too that we're holding this hearing, especially at the beginning of Older Americans Month. Just a little bit of about Iowa in our home state. We rank about fourth highest in the percentage of population age 65 and older around the country, and according to census data, this legislation would apply to about 40% of my state's population, potentially. So that's pretty significant. I don't know how the states compare, but that's very, very important as far as I'm concerned. I was going to ask you about how you're treated, but my good friend Phil Hare preempted me on that. But did you want to elaborate at all? You gave us a pretty stunning response as far as what happened to you.
Well, I did finally last December. It was stressful, obviously, and I was starting to have some health problems that were resulting from it. And my wife and I, in fact, I went to a stress counselor, and we went through, really, why are you doing this? Is it life and death matter for you? And I said no, but I just don't like to walk away from a fight, I guess.
Right.
And he said, well, you really need to ask yourself if shortening your life is worth continuing the fight. And that made a lot of sense. And so as of December, I did go ahead and retire 4 years earlier than I had intended. I had thoroughly intended my entire career to go to age 65 or 66 to maximize my Social Security. I think there's a lot of anecdotal evidence, a lot of people I know who are also drawing Social Security much earlier than they intended because they're in similar situations. And I could give you anecdote after anecdote of my personal experiences and acquaintances that have undergone this type of thing, but it is becoming rampant out there, and I think you're probably hearing that back in the field, back in your own districts.
And that alone is cause for tremendous concern, obviously, when there is that retaliation and coercion on the part of an employer. And I'm very sorry that that happened, obviously, to you. I have a question which maybe goes to Mr. Foreman more than anyone, but anyone can respond. Given Mr. Gross's situation as an example, can you give us an idea of what information would have to be provided to prove discrimination under the Supreme Court's ruling compared to what information you had to provide previously under Congress's original intent of ADA protections? Yeah, if you'd like to respond to that, Mr. Gross, or maybe Mr. Foreman or Ms. Aldridge.
I think the majority in Gross made it very clear that it must be but for causation, which is a very high level. So you're really looking for a smoking gun comments that corporate America you do not see. There was one question whether it was a sole cause determination. I think an accurate reading of the Supreme Court's decision is that it is not sole cause, but there are several district courts that have interpreted it exactly in that manner to say, for instance, if I allege age and race discrimination, well, that is a mixed motive, therefore my age case fails. And it's thrown out on a motion to dismiss because you've alleged another classification. So again, it goes back to how this is causing confusion in the court. And the bill is trying to get us back to step one and say, let's all work off the same standard.
Mm-hmm. Yeah, please.
Please put your microphone on, Ms. Aldridge. Thank you.
It is a tougher standard than for other cases of discrimination, and it's very concerning, for most older workers, and we've heard Mr. Gross, to even bring these cases forward with the amount of emotional stress it causes, the difficulty of standing up around other co-workers and challenging the company, the expense of it. So I think to make it more difficult for older workers than for other cases of discrimination is just wrong.
Right. And Ms. Aldridge, one last question. Since this ruling, do you have any idea how many discrimination claims, are out there that would have met the previous intent of protection but would now be nearly impossible to prove because of the stricter ruling? Any ideas?
I'm not sure about that, but I do know that in the last 2 years, in 2008 and 2009, there have been 45,000 age discrimination cases filed with the EEOC, which is more than any other period of time since we've kept track of it. So my sense is that given the really tough economic times, that there are lots of concerns about age discrimination, and now they're harder to prove.
Okay. Thank you, Mr. Chair, and thank you again, Mr. Gross. I really appreciate your being here. Thanks.
I thank the ladies and gentlemen of the panel, and we really appreciate your testimony. I know everyone prepared very diligently and I think did a good job educating the committee. At this point, I would